My name is Alan Chang. I'm a lawyer practicing in Ontario. I am a litigation, family law, and immigration lawyer with Saw Law Professional Corporation. And I would just like to thank you for having me today, Tina. And then before we begin with any questions, I also need to put out a disclaimer that the information provided in this video is purely for informational purposes and should not be construed as legal advice. So to apply for divorce in Ontario, first, one of you must be a resident of Ontario for at least a year. And then when that is satisfied, we need to consider what are the grounds for divorce. There are 3 grounds for divorce. The first ground is that you and your spouse must have been separated for at least a year. The second ground is if your spouse has been physically or mentally cruel to you. While the third ground would be if your spouse has committed adultery, if one of them does not live in Ontario. So if one party does live in Ontario, they can still proceed with the divorce. The problem comes when if none of them, neither you or your spouse, are residents in Ontario. So when that happens, there is an exception, but it must meet these 2 criteria. First of all, the marriage must have occurred in Canada, and second is that you and your spouse cannot undo this marriage in your current country of residence. So essentially it is in a country where you currently reside that does not recognize the Canadian marriage. 3 ways someone can get divorced. The first through something known as a simple uncontested divorce. The second one would be a joint divorce. And the third one we call application for divorce with corollary issues. I'm first going to go in regarding the simple uncontested divorce. Simple uncontested divorce is essentially the most basic divorce in the sense that it deals with the least amount of issues. It is for people who are not going to deal with any property issues, with property division, and with people who do not have children together as well. A simple divorce is simply an application with the court requesting for divorce and stating that you only want a divorce and there's no other issues to deal with. And if your spouse, ex-spouse, does not contest this application, then the judge will be able to grant a divorce for you. As the joint divorce requires the parties to be amicable with each other, which is often not the case in a divorce proceeding. But essentially, a joint divorce is when the parties, so you and your ex-spouse, are able to come to an agreement on all issues, essentially. So joint divorce means that you agree to be divorced, you agree on the property division, on how you will want to split your matrimonial home and any other personal assets, and as well as regarding the children. So a joint divorce will deal with parenting time and custody arrangements for the children. For a joint divorce, this is something that you and your ex-spouse will have to both sign off on, and that the arrangements to be made are something that's agreed upon. And even with a joint divorce, it's not always granted by a judge. A judge will still need to consider, whether the rights of the spouses are adequately considered, as well as whether the children are protected in this agreement as well, though. So application with divorce with corollary issues, that is essentially the one that we see typically the most common, I believe. It is what you call the contested divorce. This is when you and your ex are no longer able to resolve the issues amicably, and you have to argue in court essentially and have a judge to decide for you on these certain issues. So with these type of divorces, one party is known as applicant and brings the application stating what they want in the divorce, essentially, how much of the matrimonial home, and we'll go into more of that later, but regarding how the property is divided, there will be contest of, whose property this is or how you should split the assets, and so I can go into issues regarding spousal support, if you're claiming that, and as well as with the children. As mentioned, there's parenting time and as well with custody issues and decision making for the child. And with contested divorces, they are typically long and drawn out if the parties do not settle, as in the end, if the parties cannot settle, it ultimately goes down to a judge's decision regarding how to order these. As we talked about, a contested divorce is usually long and drawn out, but then at court you can motion for the court to sever those issues, such as to separate the property division issues to be considered at a later time. But then for that kind of application, the judge does need to make sure that one party's interest is not going to be harmed by it, and as well as I mentioned before, that the children are adequately provided. So typically, especially an important part if child support payments have not been set or satisfied, a judge is not going to grant you to sever your divorce from your corollary issues. A judge will not grant you a divorce if he believes the children will not be taken care of in granting this divorce. So a judge will need to make sure that at least, child support payment have been ordered and that it is an adequate amount to be taking care of the child. Because the judge will not order someone, just for an example, is if someone only agrees to pay, let's say, $10 a month for child support, and even if the parties agree, the judge can feel that's not adequate and that doesn't protect the children, then the judge will not let you get a divorce. The other ones I mentioned regarding harm is that if neither spouse will be disadvantaged. And this is honestly in a quite limited circumstance. This is, for example, if a spouse will no longer be eligible, say for health insurance benefits due to the divorce, and that it will have effect on one of the spouse's health, then that could be a consideration that a judge may make in not allowing the corollary issues to be severed. If the divorce or the separation were to occur in the middle of your sponsorship application, then essentially the sponsor would have to withdraw their sponsorship application. So you can no longer sponsor your ex-spouse. And there's really not much ways around that though, especially when the application is still ongoing and the decision has not been made. Whereas if it is a case where you had sponsored your ex, and then your ex-spouse has received a permanent residence, and even if you were to get separated at that point, that would not affect your ex-spouse's permanent resident status. Citizenship, it does not affect it. So the only time it will affect it is if you were still processing the application. Essentially, once they're approved and receive PR status, the only exception, it's not very common though, is if you were to have separated maybe very soon after receiving the permanent residence card, and if immigration were to suspect fraud, then that could be a potential way that someone may lose their PR status as well though, because that would be involving fraud, but then that is very rare for immigration to know and suspect someone of committing fraud.